We'll reconvene the hearing and we've been discussing transport and other matters, and I believe you have a question, Keith?
Well,
or we wait till Murray gets back?
No, we're up to designation, so we'll deal with that, and the question I got from Murray will have when he comes back.
Okay. We will now move on to the next section, which will be...
Sorry to interrupt. Can I suggest that you had asked me to comment briefly on the Code of Practice approach, so do you want to go over that, and then that would tie up that issue as well before we launch into the new designations one?
Yes.
That's fine. Sorry to interrupt.
I will ask you that question.
So this is a follow-up to what Commissioner Hovell asked for, which was just an overview comment in relation to the shift from the bylaw to the Code of Practice approach. So I'm proposing to give you overview comments at this point, and then I appreciate that you may have more detailed comments or questions rather in terms of that approach, not just in this hearing but potentially other ones, but certainly the more detailed questions in relation to this transport topic, could I propose, having heard from me, that the panel might ask those questions in a minute, and we can then seek to address your specific concerns in a more detailed and considered way in a follow-up. But initially, I just wanted to make some overview observations about the approach. So firstly, I'd just observe the one is sort of, you can call it a one-stop shop approach perhaps, so that the Code of Practice approach is referred to in the plan and is considered as a part of an RMA process. So it's in one place as opposed to having the bylaw as a supporting document, and the bylaw carries with it a separate process. So it's almost a multi-pronged approach compared to this, which is proposed to be one-stop shop. It has almost universally been adopted by district councils in their second generation plans, so their second round of plans under the RMA, such as this one, it's been adopted. Just on a quick check, certainly the councils I'm familiar with have all adopted it, so that's DCC, Queenstown. As you will be aware, it also reflects the exact same standards that Southland District Council and Invercargill City Council are adopting, which is very useful from a practitioner's viewpoint because those standards are therefore going to apply across the lower corner of the South Island. So I would endorse that as a useful approach. In terms, just picking up, Tina had mentioned an enforcement and compliance point around the Code of Practice approach. And I would endorse that from Council's perspective, is that requiring a landowner to follow a Code of Practice can be slightly more straightforward in taking this approach rather than in the bylaw, because you may get to a point with a particular proposal where it has issues under the district plan and then separate issues under the bylaw, but equally the development proposal itself almost depends on one on the other. So you might have a driveway which is managed by certain requirements of the district plan, but also managed by certain requirements in the bylaw, and if you're shifting one, you have to shift the other. So that's where having that one-stop shop can be useful. And the example I might give is perhaps a resource consent where the district plan requirements are all satisfied but the bylaw requirements aren't. But in order to pursue a party to require them to achieve the compliance with the bylaw, there is no scope under the consent process. So councils can potentially be put in a difficult place if they're granting consent, but they know that there's this bylaw issue still hanging out there. They can't sort of withhold the consent. And sometimes with some landowners who might be a little bit difficult, they just refuse to meet the bylaw requirement, but you still have to give them their consent. So in terms of enforcing the standards, it can be useful just to bring that person forward into compliance with through the consent process rather than having to then engage with the bylaw. The bylaw process can be a bit clunky. It's very old legislation. The Bylaw Act actually is 1901. That was when it was first passed, and that's still in force. So I've encountered issues where you have to look back at that very old legislation. So I would suggest sometimes the bylaw can be clunky in terms of process. So you may say get a dispensation, but what if then you come up you meet a practical issue which requires a variation to the dispensation. The bylaw process isn't the easiest to navigate in that situation, but we know that the RMA and the resource consent process, that's a usual process followed. You get a consent, you come up against something that you can't fix, you get a variation to your consent. So again, the RMA process is where we can find some good fits for that. So having this one-stop shop in the same place is quite useful. Just finishing off on that administrative point, in large and complex developments, for these code of practice type issues, it can require a bit of back and forth with the developer, and if that takes up a lot of council time, it's useful for council staff to be able to charge fees for that time, so council's recovering its costs. So a consent process comes with a fee, but equally complex consent processes, those fees are charged to the big developers who are causing an issue. You know, often they will be pushing the boundaries, they'll be pun not intended, but they'll be really pushing hard up against those standards. So the dialogue between council and developers, you can recover the costs of council's time in that conversation. So that's really useful for council as a cost recovery exercise. It is a lot more straightforward in the RMA context and the consent process. Finally, I realise, Commissioner Hovell, you had talked about concrete and hard surfacing and things, and I agree that there are aspects of the bylaw which are more about standards and that sort of thing. I would feel that a number of them still have a relationship to RMA issues. So, for example, hard surfacing does raise issues of stormwater management. You would have to look at that, and we have commonly looked at those types of issues through the transport chapter. Width of accessways and formation of accessways, that goes to safety standards and road use, and then we'll come to earthworks at the next hearing, at another hearing. So I would suggest that while all standards aren't necessarily directly always explicitly an RMA purpose, for an RMA purpose or something that fits easily under the RMA, they are very adjacent to it, and as I say, the administrative efficiencies of the one-stop shop approach have been adopted pretty universally now, so a lot of parties that are coming to council will be looking for a code of practice as opposed to a bylaw in the future. With lots of talking, do you have any questions about that overview?
So a code of practice is a document that sits outside of the plan, and you heard Murray describe that under the bylaw he has dispensation powers. Can those dispensation type powers be provided for under a code of practice?
So there's a fine line between what comes in as a condition. So your conditions on a consent are prescribed under section 108, so they do need to be for a RMA purpose. If they aren't specifically for, you can't have a flashing lights RMA purpose, then what will commonly be adopted is a condition which notes the actual purpose. So it may be in order to observe the code of practice requirements for a standard. So the council is bound to only impose conditions under 108. But then if the standard introduces aspects, for example, which the Three Waters team are strongly requiring, then that may be dealt with through the appropriate wording of a condition and any advice notes on that. And then those conditions are obviously enforceable and able to be varied, but then the advice notes sit there underlining them as well. So there are processes where a condition has become an issue for a developer, say, and the condition is relating to the code of practice, and the ability for council to enforce it is tied to whether or not it's a condition or an advice note. And if it's only in an advice note, then the council has to have a dialogue with the developer as opposed to it's strict enforcement. So it's not a dispensation process so much as it's comes under the consent implementation discussions, I would say.
So in summary, no.
Well, I think in the main it will be picked up in the conditions, and
Yeah,
from my
yeah.
experience, there's very little that isn't covered.
Because and I've got the bylaw in front of me, and it includes things like the process that has to be gone through before the council will accept a stormwater or sewerage main for incorporation into its network.
Yeah, and I think probably some of those, so for example, the stormwater connections, a much shorter bylaw can prescribe for example, the more technical plumbing aspects. I wouldn't expect that always to be in, though there's, what's the policy? I'll have to have a look. So again, this is this sort of thing I'd really like to address as a specific issue in a reply if I can, to be able to give you, so for example, there's a, the connection one, the plumbing connections one, I think that's a policy perhaps, that then supports it. I'd have to check that, sorry.
So a policy in the plan or a policy in the bylaw?
No, policies don't sit, well, no, sorry, not a plan policy. And would you mind just raising that question in terms of a stormwater connection as a specific question, because I do have a specific response that I can give to that, but I would need to give you the correct reference.
As part of construction, there's things like the construction process itself that doesn't sit in any, not like the Building Act where at different steps you've got to have inspections. So under the bylaw it talks about the processes that you do your earthworks, it gets inspected, you put in your subgrade material, gets inspected, etc. And to me that sort of thing doesn't fit naturally with RMA type processes, and I think you've just described that there may be other documents sitting outside then, so how do they get enforced if they're not a bylaw?
I think, so again, I'd like to discuss this here, but I do have specific examples that I'll be able to give you. So through the advice note to a condition, it can refer to an information document that the relevant council group can provide. So for example, for stormwater, there might be a guide that's provided. For other connections, there might be a policy that sits behind it. And then that becomes quite universally known within the community and practitioners in terms of the construction approach. But then what you were describing did sound the base course, the laying of base course and inspections, that did sound more like a Building Act issue to me.
For roads and the like, it's outside of the Building Act, yeah.
Yeah, so I'd probably have to again look at the specific example. I do agree that you do need to consider that whether it's for an RMA purpose, and some of it's about administrative efficiencies, and a call does need to be made there in terms of the extent of the code of practice. So the code of practice that's been put forward is the one that's been adopted both by ICC and STC. So again, that uniform approach between councils is useful because everyone's expecting to construct it in the same manner.
That's helpful, thank you, and I'm mindful that when I pose questions to Murray that he's comfortable with the transition. So in terms of the advice that we're getting, it is a consistent message that's coming, and that's really what I wanted to test with Murray.
Yeah, sure. So Shirley is going to provide some details about the designation process because it's a little bit different from the other processes we've been dealing with in the plan. I just want to, as a start, note a correction to my report on designations. So on paragraph 43 in the section 42, I've listed the designations that are rolled over with just minor modifications and no submissions, and they must be rolled over. PWN 5 should have been in that. It's a new substation at McNab. And I've also made a reference that they're all in Appendix C, whereas I only included the full chapters in Appendix C. They were unchanged. So you should note that GDC 1 to GDC 4 and PWN 1 are included in those designations that must be rolled over and should have been included. I should have split the chapters and put them in Appendix C. So yeah, please note that.
Yeah, that then includes Cooper's Wells, and so
Yes.
the conditions that were put on it at the time the designation was done are still sitting there in their current form. So I guess we can use clause 16.2 to correct the title of the general manager, which has changed since those conditions. But there's also some conditions in it requiring, or one condition, certain things to be done within 12 months of the designation being put in place, and one would think that that is no longer required.
Yes, that may be so. Council did ask for it to be rolled over without any change, so might need to get advice about whether we can do that. So I might just hand over to Shelley for the overview.
And just before you do, Shelley, I don't believe it's in the power of this panel to commit council prepare a code of practice. Prepare a code of practice. That must come from a decision of council, not from the steering panel. So we're invited to include something in the plan to say that there will be a code of practice here. In the same way that the council received a report and resolved that council would deal with financial contributions by way of development contributions outside of the district plan, a report will be required to council at some point with regard to a code of practice.
Thanks. I'll make a note of that. So, conclude on the transport chapter.
Mike?
Oh, thank you. The legal submissions that were provided, just seeking there to assist you with the designations process a little bit more. Obviously, you've been following one process to date, so just wanted to redirect your attention to the decision-making process which differs in relation to these designations. Would you like me to go through that? I can do it in a concise way, or I can read. The process to be followed by the panel here in order to properly consider and make recommendations or make decisions on the various requirements, which I also call designations, so that's that interchangeable word, differs from the decision-making process followed for other parts of the proposed plan. So for the other parts of the proposed plan, you're making a decision pursuant to Clause 10, Schedule 1 of the RMA. In this particular part of the hearings, you're making decisions pursuant to Clause 9, Schedule 1 of the RMA. And Clause 9 tells you to make decisions under sections, sorry about all the legal references, sections 171 and 168A. Now those two provisions are attached to my submissions, and the key parts for the decision-making process, or what you're considering for your decision-making process, is 171 2 and 2A, and 168A subsection 2 and 2A. So the reason I'm giving you two section references there is section 171 applies when you're considering requirements from NZTA, from the Ministry of Education, and all of those requirements which have been sought by other parties outside council. Section 168A applies to the process you must follow when you're considering Gore District Council's requirements. So in terms of Gore District Council's requirements, you make a final decision. In terms of all of the other parties' notices of requirements, you make a recommendation back to that requiring authority. So I then review at paragraph 9, I very quickly just set out the process that must be followed for requirements, and we touched on that when we spoke to NZTA. It is a very specific process for notices of requirement, and that's because they can be quite onerous, so you do have to be very careful when a designation impacts on private land, and that process must be followed in order to give a private landowner sufficient notice that they may be affected. So perhaps the process, the order of my discussion, I just give an overview of designations. So it's a method by which a requiring authority can protect the opportunity of using land for a public project or work. So it can be prospective, it can be that land is empty and I want to put a rubbish dump there. I'm a requiring authority, I want to put a rubbish dump there in 5 to 10 years. I've got funding in order to marked in my long-term budget for that rubbish dump. So you ask for a designation to sit over that land to protect your ability for a rubbish dump. So it can be future focused. Alternatively, it can be a method by which an authority is given to enable a public project or work by a requiring authority. And it's a different type of authority than a resource consent. So it's an alternative method available only to requiring authorities such as council or NZTA or Minister of Police, an alternative method for obtaining authority for their public project to go ahead. The Public Works Act is a means for acquiring land for a public work, but certainly it's adjacent in terms of that's specifically only for public works as well. Designations can be very specific. They can identify specific works on a particular site and have detailed conditions, or they can be very general. So some designations can be just for a hospital, full stop. So where there is a very general designation, the Act provides for the council to still consider the details of that development through an outline plan process, and that outline plan process is also available for where a public work or a public project is being upgraded, say, and then a new outline plan will be provided to council for it to consider in terms of the details of that development. The outline plan process does involve a back and forth between council and the requiring authority. When the plan's submitted to council before construction commences, a dialogue can follow about refining the development, could talk about conditions. Usually an outline plan will show the bulk and location of the work, finished contours of the site, access, landscaping, and any other matters relevant to resource environmental effects. Once in place, a designation removes any need for the requiring authority to obtain resource consents, which might otherwise be necessary for that same activity under the district plan rules. It gives the requiring authority consent to do, or authority to give the ability to do anything in accordance with the designation, and it prevents the use of land, including potentially adjacent uses, which might prevent or hinder the public work without written permission of the requiring authority. So for some services, it might mean that there's a limitation on works adjacent to the designation because the requiring authority is worried about, say, earthworks might interrupt services which are sunk within the designation area. The provisions of the district plan remain in place over a designated site, but only apply to uses of the land other than for a designated purpose. So this is most relevant where a designation sits over a rural property. So perhaps for a lines company, there might be a designation sitting within the lines corridor, which will limit say the farmer's ability to undertake certain activities under the lines designation. So turning then to the statutory considerations for you when considering the designations. At paragraph 18 of the submissions, there are similar requirements, similar considerations that you will need to review in relation to Gore District Council requirements and all of the other requirements from other parties. And I summarised those in my submissions. But there are separate decisions that need to be made. So I touched on this in my initial comments for designations of a requiring authority. You can make a recommendation back to that requiring authority. For any designations of council, a decision, a final decision is made under section 168A. When considering notices of requirement and any submissions received, the panel must consider the effects of on the environment of allowing the requirements, and when doing so, must, subject to part 2 of the RMA, have particular regard to. So here on page 5, I'm setting out all of the things that you need to consider in relation to each requirement, and that is specifically for the new requirements and for the requirements which are modified in a substantial way. So later in my submissions, I've grouped the different requirements by the extent of decision decision that you will need to make. Some of them you don't make a decision on at all because they roll over. Some of them have only minor amendments, and I would suggest you don't need to go through the full process in terms of minor amendments. But for those which require, which have changed slightly since the Operative District Plan or are new requirements, then you do need to look at this list of considerations when making your decision. So the things to consider are the matters set out in the Notice of Requirement, any relevant provisions of national documents, so National Policy Statement, Regional Policy Statement, any plan or proposed plan which might be relevant to the particular activity or the particular location. This subparagraph C, which is on page 5, this sets out a consideration which only is relevant if a requiring authority does not have an interest in the land. So we heard from NZTA there was an area of land where they didn't own the property. This consideration is potentially relevant there. Or if the work, it is likely the work will have a significant adverse effect on the environment. And then in either or both of those two cases, it will be necessary for the panel to consider whether adequate consideration has been given to alternative sites, routes and methods. So back to the compulsory requirements. So C is the one where you're not sure if you're applying it in relation to each particular designation, but D is a compulsory consideration, whether the work and designation are reasonably necessary for achieving the public project objectives. Other matters that you consider, so there is a catch-all there for other matters that you think are reasonably necessary to be considered in order to make the decision or recommendation. And that final paragraph F, that is in subsection 2A and 4A, any positive effects on the environment which might be offered by the requiring authority. So perhaps they might offer planting, or they might offer something of benefit to the community that may be considered as well. Just turning to the specific words reasonably necessary. So under paragraph D on page 5, the Environment Court has considered those words reasonably necessary, and the Environment Court suggests that consideration of whether a public work is reasonably necessary includes considering whether there's a connection between the works proposed and the requiring authority's objectives for which the designation is sought. So NZTA's objectives are pretty clear. They manage roading. You'll have a lines company, obviously they manage lines. So the objectives of the particular acquiring authority and whether or not the works proposed are connected with their objectives. GDC will have much wider objectives, but it needs to come through in one of their purposes. Whether the land required for the area of the designation is justified in relation to the works proposed. So that's just keeping an eye on whether or not it's a proportionate designation in relation to the need, and whether the land is able to be used for the purpose of achieving the required authority's objectives for which the designation is sought. So they're not just holding it, and it won't turn out to be necessary in the long run. So in this next section of the submissions on page 6 and following, I just group the different designations, and I'll probably take Tina's advice if I've mucked any of these up. But there is a group of designations for which there is no decision that you need to be made. They must be rolled over as is, and they are listed there. They're also listed in the 42A report. So that is because they haven't changed, and because no submissions have been received. So those designations need to roll over into the PDP without any decision required. The next group of designations don't call for substantial consideration or analysis in my submission, because only relatively minor changes are proposed, and also because no submissions were received, or rather submissions in opposition have been received. So the list is short on that one. Transpower TPR1. There are also the slightly odd ones where you have designations for which a submission was received in support only, so not opposed. So I would suggest those ones can fall in this category as well, and are listed there. The NZTA designations did actually sit within this category, but there is the curly issue of the extended mapping area, which perhaps means that they do need to be looked at more carefully. I think we've already discussed that, but my submission on that point is that the panel does need to be very careful extending any designation over private land.
Just on that, I'm looking at section 181, alteration of designations. And what that says is that acquiring authority may at any time give notice. In subsection 3, the territorial authority may alter a designation in its plan if the alteration involves no more than minor change and involves only minor changes or adjustment to the boundaries, and written notice of the proposed alteration has been given to every owner and occupier of the land affected, and those owners or occupiers agree with it. So 1813B doesn't say who writes to the landowners, which I think, in my view, leaves it open for us to. And then we've got to get feedback from them in terms of do they agree, and if they don't agree, we can't use that process.
I'd suggest that section 181 provides for an alteration to a designation in a district plan, so I would suggest that provision provides for a new process to be commenced. If that was done, there would be scope for that process to catch up to this one and potentially join in, but that process, so it's a specific process, you must do it. And same with the original process that was followed when the plan was notified in terms of requiring authorities' engagement with other parties. There's, process step ABC. So this process could potentially be commenced and catch up with our current process, but I wouldn't suggest that this is a process. The section 181 process is one that sits within what we are. It is a new process.
So if NZTA want to trigger 181, it's for them to do it, but it's probably the path of least resistance in terms of what we talked about earlier.
I think the path of least resistance actually is for NZTA to decide that it's not so significant that it warrants a fight, because we heard from them that it wasn't a significant extension of the designated area. We also heard from them that the road was already formed. So for them, the risks are probably relatively minimal. So I would suggest at this stage it's in NZTA's hands for them to consider whether they want to push forward with it, and then from there, yes, to be proactive about what process they want to do that through.
Right, so as part of the follow-up, we should be asking for your advice as to what you think is the process that we should be following. And you could respond that it's really up to NZTA for what they want to do.
Yep, or just direct NZTA to advise whether they want to pursue with the extended mapped area.
Oh, okay.
And if so, how would they propose to deal with that?
Yeah. So that should come from us then in terms of a minute back to NZTA saying how do you want to deal with it.
And the reason for my suggestion is we've set out in our submissions and in the evidence, in Tina's evidence, our position or recommendations in that regard. So really, unfortunately, Ms Dempster and her colleague hadn't had the opportunity to review that. So perhaps once they have had the chance to do that, they can make those decisions internally.
Just ask, so if they do procure the land and then is there any consultation with the landowner if they go back to them for payment of that land?
Yeah, it's a huge process, and it's the Public Works Act, which you just referred to. So, yeah, very complex process, and it might push it up the queue in terms of priority for acquisition. So perhaps on that basis, the comment I've got in submissions at paragraphs 26 to 27 need to be subject to what we've just discussed. I would suggest it's no longer the case that it's in the heading of rollover designations with only minor changes, so that's probably my error there. Certainly in terms of the original mapped areas, it does fit within that category, but if they are to be over the extra areas, then it becomes more complex.
So with Ministry of Education and there are submissions lodged, are we to make a recommendation?
Yeah.
So that's next on the queue. So if in paragraph 28, I have referenced the Ministry of Education designations, not the two new ones, all of the other ones. And I would suggest that as a change to a term because it is a change to a definition. While I don't think it's a minor amendment, I don't think it's a significant amendment, and perhaps that's something that Tina can speak to in terms of actual consequence of the amendment. But I think you are confined to considering the extent of change, which isn't huge for those rollover ones from the Ministry of Education, accepting the two new ones.
Right, we still need to do that as a recommendation.
Certainly, yes.
Yeah.
Yes. And you have to make a recommendation on the minor amendment ones as well. So for rollover designations with deleted conditions, in my submission as council, I would suggest those are relatively minor as well, because really it's just recognising the on-the-ground situation. So yes, Commissioner, for all of those except for the ones which are rolled over with no submission and no change, I would suggest the panel will need to make a recommendation back to the requiring authority what to do. I would suggest that your recommendation is relatively straightforward as the changes are quite minor. In terms of the new designations for the Ministry of Education, I would also suggest that the recommendations in respect of the new school sites are relatively straightforward on obviously only one submission, and that submission's in support. That's from a legal perspective. You've got your own recommendations. Finally, in terms of the Gore District Council new designations, so not the 4 ones, GDC 1 to 4, but 5 through 12, there were only submissions made in respect of new council designations 10 and 11. So once we're talking about the Gore District Council ones, just reminding you again, this is a 168A process, so this is a final decision, not a recommendation. you do need to consider all of the same things you consider when you're making a recommendation, but you are making a final decision, so it's not going back to another entity to decide whether to accept your recommendation. In terms of the requirements for which no submissions were made, you probably have a narrower range of issues to consider under the headings, but I would suggest that you consider each submission separately, and I acknowledge my omission and my submissions in terms of not assisting you with the decision process, and I apologise for that, and I have some notes which I can speak to shortly in that regard. I just have some notes there. Obviously, I've set up above the considerations for each decision on a requirement, particularly the more substantive ones. A couple of notes reflecting that the GDC 10 is to be more specifically considered later, but these submissions may assist you in terms of the process you follow for that decision. Also note that for the GDC designations and the Ministry of Education, the Ministry of Education ones, we thought maybe they didn't own the site, so that does mean you may need to consider the question about alternatives, but for the GDC sites, they are all owned by the council, and also the Section 42A officer has not identified any of those designations are likely to have significant environmental effects, so I would submit it's not necessary for you in your decision to consider to undertake an alternatives assessment. So turning then to, in terms of your decision and what you're going to produce following the hearings, I've just made some notes to speak to, and I will include them in our reply just for reference to assist. So you do make an overall judgment with reference to the matters in 168A and 171, whether to recommend or decide to confirm, modify, include conditions, or cancel a notice of requirement. So those are the four options for your decision. You can either confirm the notice of requirement as is, you can recommend or decide to modify the notice of requirement, you can include further conditions, or you can cancel the notice of requirement or recommend cancellation of the notice of requirement. When you make that recommendation back to another entity, not council, so this is the 171 process, the requiring authority then makes a further decision within 20 working days, and then that process follows the one set out in the Act. For the final decision, obviously that's final, so for the GDC ones, there's no further process that follows. Sorry, just looking at my notes. In terms of the sort of format of your decision, I'd suggest, it will probably follow something quite similar to what you're already doing in terms of submission points, so, but be more fulsome in relation to each notice of requirement, so perhaps with an introduction, just giving an overview of the notice of requirement and the project, working through the content and any issues raised in submissions, if there were any. Identify and consider any issues arising out of your issues, which are set out in 168A or 171, specifically for that particular requirement. And then note your, having noted your reasoning and rationale, make a recommendation or a decision to confirm, modify, impose conditions, or cancel the requirement. Hopefully that helps. Yes, to a graduated degree. So some of them are minor amendments, so not too much is probably required. Where there's no submissions, you probably don't need to think about that. But you do need to be familiar with those considerations in 171 for requirements from other parties, in 168A, but most particularly when there's a submission that flags an issue that's relevant to those points, or where you have a concern based on your understanding of the notice of requirement and the particular location.
Tina, just before we come back to you, Murray's just arrived back, and I just have one question to follow up with Murray. In terms of the transport rules that are in tables that describe the different roading types using the one network, whatever, I understand you are working on a map that shows those roads. Is that correct?
We can definitely provide that, yes.
Because my concern is that over time, potentially, the status might change, which impacts on the rules. So really the district plan should have the map in it now. It's physically a map as part of the decision, and it'll be on the council map page showing all the roads.
Yeah.
So I guess it's really confirmation that what we see or what people see is what applies.
Yeah. So we can provide both a map and a list, or one or the other, whichever you prefer.
Well, given the long list, I think a map that's scalable is fine, and yeah, that'd be helpful. That was all I had. Thank you.
Yeah. Okay.
Thanks. Tina.
Yes, sure. So, are we back to designations?
We are back at
Excellent. So, very briefly, really, is that my recommendation is to confirm most of the designations. Most of them are rollovers, and that includes where the Transpower and PowerNet, where they've asked for construction conditions to be removed. The kind of slightly curlier one was in relation to NZTA, which we've already touched on, and that's mainly because these landowners weren't notified, and we didn't know about the changes until too late in the process, really. In relation to the Ministry of Education, there's the 2 new Catholic schools, and I have recommended a modification that you include conditions in relation to one of the schools has a notable tree, and there's that they should comply with that or the notable tree rules, and I've also recommended a condition in relation to height boundary controls just to protect the residential character and amenity of the surrounding area. And yes, should note that because they are Catholic schools, these are, I think it's the diocese owns the land, so it's not the Ministry of Education, so just keep that in mind. In relation to the Gore District Council, we're dealing with the East Gore water treatment plant separately, but most of the new designations are around established water treatment plants, wastewater treatment plants, and we also got the landfill area, and so for those ones I have recommended that they comply with the noise levels of the underlying zone, even though the submissions were in relation to specific water treatment plants. I think the same principle applies to all of them, and also in relation to light spill. I've also recommended to include a landscaping condition if the facility is within a residential area. So that's the designations, absolutely.
Just a question around that. I'm just wondering, in the conditions for the East Gore water treatment pump station, you've got to generally, this is an A, generally identify areas in the range of species to be planted. I'm wondering if we should have height, range and height, or do you consider that range means height as well? Because if we're, say there was some plantings close to homes, it could be
But
shading
e-school
effect
water
or-
treatment, we're not talking about today.
I'm just talking about the conditions in the designations chapter.
Yeah, so it's the designation, we've got a separate hearing for the water treatment plant
So when will that be?
on the 14th of October,
Okay.
17th.
But it's,
17th.
I was looking in here.
I know,
at-
I
so,
know.
Yes,
Just, we've got to be clear.
all right, thank you.
The same condition applies to a couple of the other ones too, though, so your point remains valid for those ones. The wording I used was, sorry, sometimes with landscaping you say things like should, completely screen. It's more, they're pretty big tanks, so I don't think it's practical or even desirable that they be completely screened. It's more to soften the visual impact. I can look at the wording in relation to if you think the height of vegetation might be relevant, but it's important, I think, to set out what the reason for looking at the height is. Is it for screening, or is it, as you said, for a concern about shading on neighbours, so that that's really clear?
Yeah,
yeah.
it's just around neighbours really,
Yep.
and shading, and if they were deciduous trees, leaf
Or
drop
if-
causing problems for them, and
Yeah.
different things like that, yeah. Thank you.
Do you have any other questions?
On page 31, which is the power net notice of requirement, there's reference to, in relation to noise and referencing buildings erected after 18 April 2019. What's the significance of that date?
I am assuming that's the establishment of that substation. So it was probably what the receiving environment was at the time. But I would have to go back and look at I'm not sure is the short answer, but that's what I thought.
And I take it that we do have the authority to make some changes here where it refers to the manager of community and strategy, because we don't have one. Yes, so we have the authority to do that.
You actually have more scope in these decisions than you do in any of the other ones. It's not as...
Yeah, just clarifying. Thank you. Because it's mentioned about 9 times in the...
You'll get back to us with the explanation of that date. 2018.
I'll look up the requirement actually, if I can't.
I think I have a copy of the notice of requirement for that one, so I need to go through my files to find it.
It'll be on the
Yeah, it should be.
council website.
Yeah.
So I'll come back if I can't find it.
Perfect, thank you. Those were pretty much my recommendations, or they were my recommendations, so yeah, we're happy to take questions, yeah.
Look, I've got no question. I guess in some respects, there's some questions you shouldn't ask in public. So,
So from the hearing that we've had in public today, there's been a bit of toing and froing on a number of things, and I don't know if you've had an opportunity of drawing up a list, but of things that we're coming back on, and in no particular order. I've got down the way notes are dealt with as part of the rules and where they should be located will be one. We've just talked again about the NZTA designations and the process to follow for those amendments. There'll be a query coming from us in terms of signs inside windows and particularly the digital type signs. And associated with the signs is the split, not only of signs but also access ways between the way that state highways are dealt with and other roads. So they're just signs inside windows and separation distances. Be seeking some clarification between the relationship between the Building Act and district plan processes, was it, or by law?
How a policy could sit behind the code of practice.
We'll have a look at what we've got to date in terms of site versus land holding and the way that that's written, and we may need to come back and ask for that to be talked about more as part of the subdivision chapter dealing it up. There's a minor thing about speed zones as to whether that's a physical feature of some sort. So that's all I had on my list. Is there other things that you've got there that we should be picking up on?
Your definition.
Should we have vehicle movements in that as well?
Yes, yes, yeah. Joan?
Sorry, was that in relation to the equivalent car movements? Yeah, perfect. And that was about splitting out the local and the highway rules. Yep.
And in relation to temporary activities, I will have a look at temporary or temp R9, which is a demolition rule in relation to those definitions where they refer to historic heritage and that vegetation aspect of that rule.
Murray also provided some clarity around the N for Neville. So it's the space in between the adjacent vehicle access it's just the reference probably be included. Like, so the distances are included in the table. They just in reference should also be included, and that would make the diagram clearer.
From what I heard, it's left up in the air as to whether N for Neville was actually required, because he made the thing that was used that much.
Yeah, that's right. It's in there. The distances are in there already. So they are in the table. Yes. Yes, they are. Yeah, that's right. So the distances are there, but it's just the N reference wasn't. So which is why you didn't find it. So that can be included as a correction.
And the table that's got train on top is the heading.
Yeah, that's right. That's a correction as well. So yeah, I've got a couple of corrections to provide for you as well. Yeah.
So we will come back in the next few days. So I think that takes us to the end of where we're at today, and we can begin to deliver it. Make these people get home.
appreciate it, and we will adjourn until our next wee bit. We'll adjourn to deliberate, but thank you very much. Okay.
Safe travels, and we've got 35 minutes until the council meeting starts. So it's good. Thank you, Lindsay. And